Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about arbitrary detention. Cases that should have gone to the Supreme Court of Canada, but didn't. Travis Turgeon was observed driving erratically by the police, who thought that his vehicle was stolen. Later, the police determined that he was in fact an impaired driver and had not stolen the vehicle at all. Mr. Turgeon argued at trial that he had been arbitrarily detained by police because they did not reasonably believe that there was ongoing criminal activity of a sufficiently serious nature to warrant an investigative detention. Mr. Turgeon attempted to argue that the idea that criminality could lead to investigative detention required more than just offenses that didn't pose any public safety risk or were minor, and required the officer to have something more than a reasonable suspicion when it came to driving behavior to detain a person for a criminal investigation. The court disagreed. Mr. Turgeon sought leave to appeal to the Supreme Court of Canada, and that was denied. And this case does raise a very important issue. There are already Motor Vehicle Act laws in every province and every territory in Canada, as well as laws that arise at common law that give police the power to stop vehicles for the purposes of checking sobriety. But where police are using instead their powers of investigative detention under the Charter to stop individuals to investigate criminal offenses, shouldn't there be something more than minor motor vehicle violations or the Motor Vehicle Act power when there isn't necessarily a connection to any criminal activity, because an investigation into sobriety doesn't mean a reasonable belief of ongoing actual criminality? This is an important issue that the Supreme Court of Canada could have addressed, especially because issues related to police powers to detain individuals have consistently been recognized by the Supreme Court of Canada as being overused when it comes to Indigenous individuals, Black individuals, and people of color. And when the Supreme Court of Canada has the opportunity to perhaps make the playing field a little bit more fair when it comes to police interactions and police powers to stop private citizens, this calls out for the Supreme Court of Canada to address the issues. Hopefully the Supreme Court of Canada gets another case in which it does investigate the power to detain individuals for motor vehicle infractions that don't fall within the scope of investigative detention and determine whether there is a distinction between the two for the purposes of impaired driving investigations. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.